Hey everyone, today we are diving into something that every business owner, employee and even consumer should understand when it comes to contracts: implied terms. Now you may have heard of express terms, which are those that are explicitly written in contracts, but what about terms that are not written down but may be binding? These are called implied terms, which are provisions that are not expressly stated in a contract but are assumed to be part of it, either by law or by the nature of the relationship between the parties. In Singapore, implied terms can arise in a few key ways. First up, terms implied by law. These are imposed by statute, such as the Sale of Goods Act, which implies that goods must be of satisfactory quality. Number two, terms implied by fact. These arise from the presumed intention of the parties based on the specifics of the agreement. Number three, terms implied by custom or usage. These come from established practices in a particular trade or industry. Let's start with a very common example: buying goods. Under the Sale of Goods Act in Singapore, there is an implied term that the goods sold must be of satisfactory quality. Imagine you buy a mobile phone and it turns out to be defective. Even if the seller didn't specifically say that the phone works, the law implies that it must be fit for use. If it's not, you have the right to remedies under the law. This protects consumers from unscrupulous sellers and ensures that businesses maintain quality standards. Let's move on to another example of a term implied by fact. Let's consider an employment contract example. Imagine an employee is hired for a full-time role, but the contract doesn't specify working hours. Even though it's not expressly written, the court could imply that the employee is expected to work a standard full-time schedule, typically 8 hours a day, 5 days a week, based on common industry practices and the nature of the role. Moving on to terms implied by custom or usage. In the construction industry, certain practices are so common that they become implied terms through custom or usage. For example, there might be an established practice that subcontractors are paid within 30 days of submitting their invoices, even if it's not explicitly written in the contract. The courts may imply this term based on the fact that this is a common practice in the industry. However, you should note that not every term can be implied whenever you feel like it. For a term to be implied by fact, it must satisfy the officious bystander test. Essentially, the term must be so obvious that if a bystander were to ask the parties, should this be part of the agreement, they would say, of course. It's also important that implied terms do not contradict any of the express terms in the contract. So there you have it. Implied terms may not be written into your contracts, but they can still have a significant legal impact. Whether you're a business owner drafting agreements or a consumer signing on the dotted line, it is essential to be aware of what terms could be implied into your contract by law. Thank you for watching. Don't forget to like, share and subscribe, and I'll see you in the next video.